just to mention, we will record the session. So if anybody wants the recording afterwards, we're happy to share that. Thank you for joining. I think we've got a pretty good turnout today, and I think hopefully some of you also attended the Finance Magnet conference, and I think there was quite a lot of interesting things said there, especially by the FSCA, which we will deal with in this presentation. Maybe just some quick introductions. So I'm Sean Barnett. I'm a director at Norton Fulbright, specializing in financial markets regulation with a particular focus on asset management and derivatives. We've got Lenny D'Offrio, who's also joined us from Oracle. He'll talk about some recent developments in the compliance space. And then there's Reddy, who's a director at Norton Rose with a general financial market regulatory practice as well. And she'll talk to us about some of the recent ombudsman decisions. We could hold, and I'm sure there'll be some questions as we go through this. Some of the topics are quite topical in the sense that there's a lot of FSCA activity around them. So I'm sure some of you will have some queries. If we could keep them to the end, I just want to get through the presentation. If you want to write them in the comments section in the interim, in case you're worried you'd forget them, we'll collate all those at the end, and we're happy to stay as long as it needs to deal with all your queries. So the order of events is Lenny will speak to us first about compliance-related matters. I will then, with Kristen and Lesegu, speak about the ODP side of things a little bit, focusing specifically on how ODP regulation overlaps or doesn't overlap with the Phase Act regulation. We'll then touch on copy trading, which some of you may be aware will focus areas of the FSCA at the moment. And then Des will talk about some of the phase ombudsman lessons for 2020. So in that context, I think time has moved on a bit. If we can pass over to Lenny to get us going on the first one. Thanks, Lenny. Lenny, I think you're on mute at the moment.
Morning all. I just wanted to thank everybody for attending. I know it's quite early, so we appreciate that. I think some of these topics are critically important for our sector of financial services that we're discussing today, primarily the CFD sector, where there's been a lot of media scrutiny or topics raised by the FSCA. And I think it's creating some consternation, in the sector. So I think what is critical for me, if I use an analogy that Elon Musk uses, and love him or hate him, he is one of the biggest industrialists of our century. I think it's important to always go back to what he calls first principles. I think it's a physics term, a scientific term. And that's why it's a privilege to have Norton Rose here, because our first principles is the law, the statute, and then the subordinate legislation under that, and then any codes of conduct. So anything that is published, promulgated, and issued is what we need to abide by. Now, there has been a lot of talk in the industry. If you've been to, and the first thing I'm going to talk about really is the outcomes of the FSCA enforcement conference, which happened earlier this year, and some of the items that are topical for them or areas of focus. And really it does impact us as a compliance practice. So I'm going to talk a bit about the things that have been keeping us busy over the last 4 months in terms of our sector that we are focusing on today, and that is the CFD sector. So coming back to first principles, it's important that we don't listen too much to verbal communications or things that are not promulgated. And ideally, at the end of, not necessarily at the end of the session, but this would be the beginning of trying to establish business models that are based in truth, and the truth is the regulations. So if I can turn now to some of the outcomes of the enforcement conference. One of the big areas that the FSCA concerns itself with at the moment and because it's new, is the ODP regime vis-a-vis the FSP or phase licensing regime. It is clear that it is an area of focus. We've received numerous investigative queries from enforcement, and these are typically generated from complaints from the general public. So as soon as the FSCA receives a complaint, it is obligated to investigate a complaint. Unfortunately, clients don't know quite who to direct complaints to. Is it the Ombud? Is it the FSCA? Is it the compliance officer? So they bomb out complaints, and the FSCA is inundated, and they have a backlog, which I think creates a situation where it puts our industry into the spotlight. So really, the big issue for them is that, if the second point is that the FSC clarified at the conference that it does not suffice for entities wishing to issue an OTC derivative to have a phase license. These entities must obtain an OTC and ODP license. Now, that's very clear. I think we all know that you cannot be a market maker or the issuer or counterpart or act as principal vis-a-vis a South African client in South Africa unless you have that ODP license. However, there are business models which allow an FSP to act as intermediary between an ODP and the client. And so the FSP is concerned that there are instances where FSPs are acting as intermediaries without the proper licensing, and the activities that they're doing might border on the issuing of a CFD, and they're not actually registered as ODPs. And so they are looking into this. To give you an idea, we received a spate of investigative letters from the FSP against a number of our clients asking, what is it that you do? Who is your ODP? Are you an ODP? Are you issuing the derivative? And these are the kinds of questions which are quite intrusive and quite thorough, asking about the business model, you know, that is being used. And we are sure that they will make examples. It is an area of focus, and that is one of them. And Sean is going to talk to that a lot, so I'm not going to carry on too much about that. You know, the other area is, what is the responsibility of the key individual in these arrangements? A lot of our ODP clients have contracted key individuals. Now, you know, we call them outsourced key individuals. The FSCA has a view that, and correctly so, you are either a key individual or you're not a key individual. If you are a key individual, you have certain responsibilities in terms of your operational ability, your oversight over the operations of the business that you're responsible for in South Africa, and the key individual is ultimately responsible for all of those. I'll talk a bit more about that afterwards. Rudine, you can possibly move forward to the next slide. So I think what the FSCA has found is that there are instances where FSPs are acting as both an intermediary under their phase license, but also are entering into derivative contracts as principal. And what they might do is hedge that out to a liquidity provider, which is a typical what they call an STP model, but really it's a hybrid. And you know, we talk about A book and B book. What is allowed with an FSP license is what is called A book. That is where you receive and transmit a trade. The FSP may not be a counterparty to a trade. It can only act as an intermediary or an introducer of a South African client to an ODP. Let's use that term. But typically the industry will call it a liquidity provider or market maker. So I think what is critical is that these hybrid models have to stop if they are in play. You cannot, you cannot stand as counterparty to half of that CFD and then hedge out the other half to a liquidity provider to protect your credit risk. So I think that is a principle, and I don't want to talk too much about that because I know that Sean will be talking about that. But this is an area of focus, and we've had many questions around business models. We have probably over 20 CFD providers. We must have received about 5 of these inquiries at the beginning of the year. So it's clear that they are looking into this area and they want to establish who is actually issuing a derivative consciously or unconsciously. That's the business model. And I think that they will come down on entities that are acting as such. They quote some case law, which was the case against Pioneer FX, if I'm not mistaken, where the individual was debarred and fined for acting as an ODP without the correct license. So it's clearly an area of focus. So the intermediary, the FSP is an intermediary, cannot stand as counterparty to a CFD trade. They cannot take credit risk. So wherever a company is potentially facing some form of credit risk because they've entered into a CFD, well, in that instance, as a litmus test, we could say that they are acting as an ODP and they would need that form of license. Okay, I think we can move on, Rudine. Yeah, and that's the hybrid model that I'm talking about. I think, you have the A-book strategies. This is, there's so many models and so many ways of cutting up this cake, but really the A-book is where typically client trades there's a receipt and transmission of trade, and that is allowed under an FSP license that has intermediary services on its license, and that is allowed. But depending on how you do it. And that's where we need to look clearly at the regulations to determine how it is that we do that. If you are doing any receipt and transmission of trades, if it's purely the operation of a platform that allows that. At the conference, Gerard van Dierventer, the deputy executive or executive of enforcement, actually stated that it's not the platform that's the issue. It is where does the credit risk lie? So any B-book activity where you are taking on some risk and pass some out is not allowed. So moving on to other areas of concern that has come out of this enforcement conference, it's actually in their document which they issued last year on the successes that they've had in instituting regulatory action against certain FSPs, copy trading, social trading, and signal provision, right? They say is a no-no. Verbally, he has stated that this is illegal. We don't believe that it is necessarily so. He did concede that each case will be assessed on its own merits. So it very much depends on the manner in which you are allowing master traders to be copied or social trading. I'll just use these terms generically, and I think the FSCA uses them generically. And they even went as far as to say that any signal provision, I don't want to use the term recommendation because that would imply advice, but any signal provision through the platform could be construed as advice. And a lot of our CFD clients are not registered for advice and don't have reps on the license that are registered to render advice. So we need to understand whether the provision of a signal is advice or would it fall within the carve-out of the definition of advice, which is this is factual advice. It's simply a view the same way as when you open the newspaper and read an opinion piece and somebody says, Anglo is a good buy at the moment because there's potential corporate activity. Is that advice? And so that's something that we need to look at, is how these signals are provided. What we do know is that these MAM, these multi-account managed accounts, or these percentage allocated accounts, for me, those would be very much more asset management activity. And certainly those individuals that are managing these types of accounts would have to be a representative on a discretionary FSP license, a Cat 2 license. And I think that makes sense because those are managed portfolios. A PAM account sounds to me very much like the Cat 2 space of a model portfolio being managed, where there's a group of clients. The portfolio manager would then decide on what the model portfolio looks like and allocate proportionally those investment instruments or the asset allocation equally across that group, in whatever percentage has been invested by those individual investors on a segregated mandate. So that for me would be a category 2 activity, certainly. But for me, and I know that Gerard said there are no gray areas. Copy trading is Cat 2. And that's why I say we need to go to first principles. And I'm very happy to be collaborating with Norton Rose, because they are the experts in cutting through the noise and saying, this is what we can do, this is what we cannot do. Another area of focus that was spoken about was the issue of Forex education. And a lot of our clients that are in the space are engaging with IBs, introducing brokers or affiliates, where we have little control over what it is that they do. We've had a number of inquiries against people that are providing Forex education. They've got academies, and finfluencers is the word that they use. These financial influencers that have big followings on Instagram, and I think that these individuals are quite aggressive. I think that the business model can create conflicts of interest as set out in the General Code of Conduct, because in the IB model, the IBs are remunerated on volumes of trades. So there's an incentive for these finfluencers to engage with their clients that they've introduced, to an ODP, an offshore ODP or market maker, or a local one, to try and get them to trade more. And we know that CFDs, and the FSCA is aware that CFDs are a risky product. They're highly leveraged. And losses are high. There's an almost a 70% loss ratio in the sector, and it's for these reasons. If you look at the reason for being for the FSCA, if we look at the Twin Peaks model, what is their role? Their role is to oversee the market conduct of their sphere of influence, and to ensure that within that sphere, customers are treated fairly. And we know that there are 6 outcomes. I'm not going to go into TCF, but there are things that they mentioned there, such as suitability. Is the product suitable for that profile of client? And so, the appropriateness test that you have when you onboard a client has now, in my view, become rather important. To say, well, are you a sophisticated trader or not? And is this product suitable? I'm not going to go as far as to say that we should be doing a suitability analysis, because we would lead on to perhaps an advisory model in that sense. But at least from a product provision point of view, what range of products do you allow? What level of leverage do you allow for retail clients that are unsophisticated? I think we should have a tiered approach on that. This is the next one, the renter KI situation. I mentioned earlier that the FSCA does not consider the employment status of a key individual. It's irrelevant. You're either the key individual on the license or you're not. If you are the key individual, you need to be fully aware of all aspects of that business, from from all functional areas, from HR, your reps, their fit and proper status, to the finances of the company, your capital adequacy or financial soundness, as it's called, the liquidity, right down to your business operations, standard operating procedures, the manner in which clients are taken on, and very importantly, your anti-money laundering onboarding requirements under FICA. So guys, these are the things that have been keeping us busy. We've been answering questions from the FSCA's enforcement department on these issues since at least January this year. I think we can move on. The next area, which is rather new for the FSCA, is the, since crypto was defined as a financial product, a number of our clients have applied to add this subcategory of product to their license. They're now called CASPs. The FSCA has its own categorization, in terms of risk profiling FSPs. So a category 1 that does not hold client funds is the lowest risk FSP. Next one, category 1 that does hold client funds. Next one, category 2, discretionary, a license holder, and then your hedge fund, category 2A. Obviously category 3, but there are not many of those in issue. We don't concern ourselves with that too much for this audience. But now we have CASPs, crypto asset service providers. It's the name given to an FSP that has that subcategory of license. Something new that the FSCA has begun in issuing these CASP licenses is that they are doing what they are calling a pre-licensing on-site visit. That is almost, if anybody's been through it, a supervision on-site visit. And I just wanted to read the agenda just at a high level to give you an idea of the level of detail that they go into to assess whether the FSP has the capability and capacity to oversee the activity that they wish to provide in crypto assets. So they start off with the business model. They want to know what the business and operating model is. In other words, are you an exchange that a person can actually purchase that physical currency? And to be clear, a CFD over cryptos does not require a crypto asset license, right? You would need a derivatives license for that. So if you have a derivative license, you can issue a CFD over crypto assets, right? We're talking about, this is a misnomer, we're talking about the actual physical purchase of a virtual currency, either as an investment or to trade in it speculatively. And so if that is what the business model is, either as an exchange or as an intermediary, then they may do a pre-licensing on-site inspection. So they look at first the business model. What is the operating model and what is the trade flow? Are you executing the trades or do you pass trades on to an exchange for your client? They want to know what your potential market share is, your revenue model, what products and services, including staking, lending, borrowing, custody. What is your target market? Is it retail? Do you deal with institutions? And then what operating systems do you use to facilitate these trades? And then when it comes to onboarding, FICA, they had a person at the site visit, which is from the FICA department at the FSCA, and they looked very closely at the RMCP and whether we have placed crypto assets as a higher category of risk product, because by its very nature, there is a form of secrecy with crypto assets. And I think that we have this disconnect between knowing your client and then entering into a product which is, it's just a key on a ledger, and I suppose quite difficult for regulators to identify who owns what, because it's not named, but rather there's a key. The other area was, well, I've spoken about the governance. I mean, they want to see that there are real governance structures in place. They asked us about board subcommittees. Now, having said this, all of these questions seem to emanate from the principles used in the application for an ODP license. And there again, in that and in this, there's nothing drafted. There's nothing that we can say, well, this is the code or this is the standard that we need to apply and to have in place in order for us to be successful in our application. So unfortunately, it's an iterative process with the FSCA, and we rely on the feedback that we get through the registrations department. The individuals that arrived at the on-site visit was not just from registration. We had people from ODP, we had people from the FICA department, and we had people from registration. So they do look at this. Their due diligence is multi sort of area, and I think it's a good thing. I really do think it's a good thing, and I think that the level of maturity of the regulator has, you know, if we look at 2015, where people, well, they weren't sure what a CFD was, to where we are now, it's definitely changed a lot. And I think the level of understanding has changed a lot, which means we will be more effectively supervised, certainly by the FSCA. But what I do believe that they need to do is be more clear in their guidance, and their guidance needs to be documented. I'll tell you why. If we go back to the KI experience, and I know some of my clients are actually on the call, we've had a situation where the same entity, the same group, using the same applicant key individuals, have had one license application go through the many hoops to get quite close to licensing, quite close to getting our pre-on-site visit. Whereas those same two individuals that were dealt with by a separate analyst in registration have had their application basically thrown out on the basis that those same two people do not have the requisite experience, because in the past, when cryptos were unregulated, they did not trade on behalf of clients. Whereas one application with the same two individuals has gone through the process and seemed to have gotten through that hurdle. So I think the cause of that is because the FSCA does not document clearly what the requirements are. And there's a lot of confusion. At first, you know, the applicant key individual had to demonstrate that they had done some form of crypto course that was taken out of the final draft, or the actual, you know, the board notice that was issued. And it just created quite a bit of confusion for us. But at least, you know, after these site visits, we are learning from them. So just to move quickly, I'm conscious of time. Hot and cold, hot versus cold wallets. The custodian sort of ship of cryptos was a big deal, and the flow of funds was a big deal, and FICA for cryptos was a big deal. I mean, it's a long list of items. It took a whole day to go through at that site visit. Okay, so that's cryptos. If we can move on now, the other area that we are seeing a lot of on-site inspections. Rudine, if we can go to the next slide, please. Right. So we've had a number of requests for FICA on-site visits. It's a thematic review this year. I feel, this is my feeling, we're on the grey list. I feel that the FSCA is under pressure to demonstrate that they have been looking into and doing inspections on accountable institutions under their sphere. As you know, the FIC outsources its oversight to other regulatory bodies because they don't have the capacity. So when it comes to, you know, casinos, they go to the gambling board, or banks, it's the reserve banks that will do the inspections. For lawyers, it's the law societies. And so we fall under the FSCA, and the FSCA seems to be under pressure to get a lot of site visits in with a particular theme, and that theme is counter-terrorist financing. So they want to see very clearly, and that's the big theme on these site visits. The theme is, how are you managing your screening of clients against the sanctions and terrorists list? Well, the only list that South Africa recognizes is the United Nations list, but they want to see that all clients have been passed through that list. And what you should be doing if you're using the FIC system is to take a screenshot to show a negative result. And linked to that is Directive 8. They want to see that all employees of the FSP have been run through that system, and they want a demonstration, they want proof, they want evidence that all your clients and all your staff have been run through that system. If you do have a positive hit or a false positive hit, they want to know that if it's a positive hit, that it has been reported, that the terrorist, has been reported, and that if it's an existing client that eventually comes up on your reviews, they want to know that you have the capability to freeze assets where it comes to terrorist financing or assets, linked to terrorist groups or whatever it is.
Sorry, Lenny, I'm just conscious of timing.
Yeah, I'm nearly finished.
More than halfway past the time.
Sorry about that. So the other one is your RMCP must match your business process. Staff must be trained, and all money laundering compliance officers must be logging into their Go AML and answering emails that they get. Guys, I know I had 15 minutes. Sorry to go over time. Those are the key areas that we're looking at, and I'm happy to pass over to Sean. I think Sean's up next. And thank you for your time, and thank you for joining us.
Thanks, Lenny. Appreciate that. So what we will do quickly now is just go into a bit more detail around the actual underlying regulations that's applicable both to the ODP regime and the phase regime, and talk for a minute about how you could potentially structure your business to either not have to have an ODP. Of course, if you want an ODP, that's a different matter. But there's a number of counterparties or parties in this market that want to operate just with an FSP license, without having to get an ODP license. And we're going to talk for a second about how you can potentially do that, where phase overlaps with ODP, regulation, if it does at all, and the type of things you must be careful for. And then also we'll touch on social trading and some of the specific structural things you may have to think about if you have a social trading or signal provision product to avoid raising the ire of the regulator. But before we do that, Kristen and Lesego will, for 2 minutes, just talk quickly about the ODP regime, what it essentially is, where it's come from, and what it regulates. And then I will talk about the phase and ODP. Thanks, Kristen. Lesego.
Thank you, Sean. So before we delve into this discussion, I just want to give a brief overview of why the ODP regime exists. So before the 2018 Financial Markets Act regulations came into place, the over-the-counter derivatives market was largely unregulated, with no dedicated authority to oversee the activities of this market. This was noted as a significant contributor to the global financial crisis in 2008. And as a result of this, the global financial market watchdogs realized the need for robust regulations that seek to protect financial market stakeholders and ensure the stability of the financial markets. The FSCA new regulations now require all OTC derivative providers to apply for a license to continue their operations and report all their transactions to the trade repository. Some of the changes that have been introduced include the changes in margin requirements for non-centrally cleared derivatives, which Kristen will discuss in more detail shortly.
Thanks, Lesego. So just as a refresher, what an OTC derivative is, it's an unlisted derivative instrument, so it's not listed on an exchange, that has been executed, whether confirmed or unconfirmed. And FX spot contracts and commodity derivatives physically settled are not included in what constitutes an OTC derivative, where an OTC derivative provider is a person who, as a regular feature of their business and transacting as principal, either originates, issues, or sells an OTC derivative or makes a market in OTC derivatives. So if you want to act as an ODP, or if you want to advertise or hold yourself out as an ODP and act and provide derivative instruments in South Africa as principal, you will need to ensure that you're authorized with the FSCA and have this ODP license. So there are certain standards that have been prescribed to predominantly regulate the ODP regime, such as Conduct Standard 1 and 2. And there are certain requirements that ODPs now have to comply with, such as conducting due diligences on their clients, since trading in derivatives is high risk. So you'll need to ensure your clients have the necessary investor knowledge and capital adequacy to invest in such high risk derivatives. You will also have to report your derivative OTC derivative transactions to an authorized trade repository, and details of this will just include the name of the parties of the transaction, the value of the transaction, the underlying assets of the trade, and the margins that have been maintained, as well as a brief description of the actual derivative instruments. Just to name a few, and an actual application to the FSCA to become an ODP will involve showing them all your policies that are in place to comply with the conduct standards, such as your business plan, your risk management plan, etc., which may need to be drafted. So the FSCA has just kept a finger on the OTC derivative markets through these regulations, and if you don't comply with it, there are some serious consequences. If you're liable on conviction, you can be fined up to 10 million rand or imprisonment of 5 years or both. So it's really important that if you want to act as an ODP as principal in South Africa, that you comply with these requirements. Thank you.
Thank you, Kristen Sehu. Rudine, if we can go to the next slide. What I then want to quickly touch on is some of the practicalities that we've seen in this market since 2019. As Kristen mentioned, ODPs, or over-the-counter derivatives, and particularly the type of over-the-counter derivatives we're talking about here, so for example, CFDs or currency pairs and the like, those were unregulated prior to 2019. And we found that a lot of the market participants that were operating in South Africa at that stage had an FSP license with derivatives as a financial product licensed on that license. And they essentially operated with that license. Now that license technically did not authorize them to issue derivatives because it simply was unregulated at that point. The license, as Lenny mentioned earlier, essentially deals with the intermediation or with advice in respect of financial products, including derivatives. I think many of these market participants got an FSP authorization to essentially be able to tell the market that they are licensed. I think there was a bit of misunderstanding in the market at that point around what a Phase Act authorization deals with. And certainly that confusion became a lot more once the ODP regime came into force. We then had various inquiries at that point around when an ODP license is needed, and whether the parties that at that point was acting under FSP authorizations were allowed to continue operating as they were. The answer to that question around when do you need an ODP license and can you continue as you were with your FSP authorization really boils down to a contractual matter to a large degree. The question is, are you selling or issuing derivatives in South Africa as principal? Now, what determines that? Two principal things determine that. The one is, what does your contractual terms say? So I had various discussions with counterparties who said, no, we operate as a straight-through processing agent. We might be taking the instructions from a client, but we then pass it off to an offshore market maker, so we don't have any market risk on the transaction. And in many jurisdictions, I believe there is a straight-through processing type license that you can get. In South Africa, though, if your client agreement provides that your South African FSP entity is the counterparty to these transactions, in other words, your terms and conditions state that the FSP is the one that you look to if there are amounts owing to you, for example, that would mean that you are issuing CFDs in South Africa and you would need an ODP authorization in South Africa. The only way to avoid that, and this is what many market participants then in fact did, is they slightly changed the way they operated in South Africa. They changed their terms and conditions to make it very clear that all that they are doing in South Africa is marketing the services or the products being issued by an offshore market maker or by an offshore. Again, very important that your terms and conditions reflect that. I mean, I've had discussions with multiple parties in this market who told me that's what they're doing. But if you look at their agreements still have them as the counterparty to these contracts. So provided that you make it clear your role locally as the FSP is just to market, that is a form of intermediation, and you're allowed to do that provided that your license, of course, includes derivatives as a financial product. However, clients must then face the offshore product issuer directly. In other words, you can't have your local party the counterparty. Another issue I want to mention here, and there's a lot of confusion around this, and it sort of ties up with the last bullet on the slide, is the issue of exchange controls. So I've also had multiple participants in this market operate for a long period of time where they transferred the trades to offshore issuers, but then collected client funds in South Africa. Now, that is potentially not problematic from a Phase Act perspective. I mean, you could potentially act as a collecting agent for an offshore issuer. The problem that arises is one of exchange controls. That South African FSP cannot collect monies on behalf of South African clients when they are utilizing their foreign investment allowances. Now, they have to utilize their foreign investment allowances when they face an offshore issuer. And when they use their allowances, the exchange control regulations require them to transfer those funds abroad. They can't transfer the funds to a local counterparty. Now, we have been involved in a number of investigations with the South African Reserve Bank, where large amounts of money held by particular CFD providers in South Africa were blocked and could not be transferred out of the country for this very problem. The view of the Reserve Bank is essentially if your clients are using their allowances to invest with an offshore issuer, they must take that money offshore. They can't have it paid or deposited in a South African bank account. So that is just something to keep in mind as well. So, essentially where we got to with what we refer to as, the referring broking model is where you have a group of companies with a South African FSP license. The South African entity with the FSP license conducts marketing activities in respect of the offshore issuer's CFD products, and that is reflected in your terms and conditions correctly. South African clients can then use their allowances, take the money offshore and invest with that offshore issuer. Now, in those circumstances, the South African FSP doesn't need an ODP license because it's not marketing or originating as principal. It's doing so on behalf of the offshore issuer. And similarly, the offshore issuer doesn't need any form of South African ODP regulation because those contracts are being entered into offshore. And it's also important, and I won't bore you too much with the law around what determines where contracts are located, but it is possible, of course, to structure your affairs in such a way to make it clear that those contracts or those CFD contracts are entered into offshore and not in South Africa. If you do all of that correctly, I think you get to a position where your offshore issuer doesn't need a ODP license in South Africa, and your South African FSP similarly would not need an ODP license in South Africa. Second matter that has become quite pertinent recently through investigations that we've been involved with the FSCA is the matter of Section 2 of the General Code of Conduct. Section 2 provides that essentially an FSP has an obligation to ensure that you look after the affairs of your client and do the right thing, and sorry, I can't remember the exact wording now, but essentially it's quite a generic obligation to ensure that you don't expose them to inappropriate risks. Now, Section 2 has been used quite extensively by Gerard recently to argue that if a South African FSP refers clients to an offshore issuer, and that offshore issuer is not appropriately regulated in its home jurisdiction, they see that as a breach of Section 2 of the General Code of Conduct, and the South African FSP would be liable on that basis. Now, again, there's their view is that you must be licensed by a jurisdiction that they deem appropriate. I mean, we probably have a slightly different view. We believe if you can show that the relevant offshore issuer conducts the same type of client-related protections that would happen, say, in a heavily regulated jurisdictions. In other words, there are appropriateness assessments, there are risk management policies, and and processes. There's capital that backs the obligations. All of those type of client protection mechanisms exist in respect of that foreign issuer. I think you have a pretty good argument that you've still complied with the provisions of Section 2. But keep in mind, if your offshore issuer on this referring broking model is located in jurisdictions where there's no offshore license, or potentially in jurisdictions where the FSCA has raised concerns. I mean, for example, I know recently they've raised concerns with Belize as an example. Then that's something one will have to look into a bit more carefully, and you'll have to be able to show, if an inquiry comes, that your offshore issuer deals with related protections and risks in an appropriate manner. All right, so that's what I want to say on that. Then just quickly on foreign and local ODP licenses, it is possible for a foreign entity, i.e. an entity that is not based in South Africa, to get an ODP license should they wish to, for example, market as principal in South Africa. I'm not sure there's a lot of benefit in the foreign ODP license unless you want to be able to tell the market that you are locally authorized. I mean, there's some benefit, of course, in that, but you can almost achieve the same outcome with this referring broking model that I've mentioned. Exchange controls I've mentioned, but just quickly, in addition to that, there are a number of exchange control issues that are relevant to the referring broking model that I've mentioned, but also generally exchange controls where there's any offshore market making. General rule, no South African entity, say, well, for example, a South African entity with an ODP license is not allowed to hedge itself offshore without going through a South African authorized dealer bank. You can, but only if you get specific approvals to do so. So keep that in mind. Many of the local ODPs therefore hedge themselves with local market makers. You can, I believe, potentially get an application approved to hedge yourselves offshore, where you can show that, to do so through, well, to do so locally or through a South African authorized dealer bank would be, too expensive, or potentially they can't give you the same type of hedging that you would get with another group company, as an example. So that is potentially possible, but it's necessary for those applications to be made. If we can then go to the next slide, I know we're sort of running short of time. Just wanted to talk about copy trading. So as Lenny mentioned, copy trading has become a very hot topic for the FSCA, and I think potentially rightly so. Now, if I can just break it down to its very basics, what they are saying, and I think there's some truth in this, is they saying a follower or a following trader that essentially gives a master trader the ability to trade on that person's behalf is now basically doing what I would do if I give my money to any other investment manager. I take risk on that person's ability to make good trades on my behalf. In the context of copy trading, currently those master traders have no regulatory oversight. So there's no requirement that they be experienced. There's no requirement that they have any specific qualifications. They can essentially be anybody. And there's been a number of cases, like the Moorcroft matter, for example, that Lenny mentioned, where people have lost money on these type of arrangements. And the regulator feels that if you're giving your money to somebody to manage it on your behalf, that person must be regulated. So I think that is probably right. And I think this is not unique to South Africa. I think there are various other jurisdictions where master traders are also subject to some form of regulation. Let's just get down to then what would be problematic in a copy trading product. Now, most of the copy trading products I've seen essentially involves a follower giving some form of authority to a master trader to essentially automatically, either in the same direction or an opposite direction, copy the trades of that master trader. So there's an element of automation. In other words, I don't get a signal and then decide myself whether I want to make that investment. The investment happens automatically. Now, it's difficult to argue in those circumstances that the master trader has not essentially affected a transaction on your behalf, which is the requirement per the discretionary code of conduct for you to conduct discretionary services, is you do that service on behalf of a client. Now, in the Moorcroft matter, for example, it was quite easy because there was a power of attorney in place, in fact, where the client authorized the master trader to trade on his behalf. But also in circumstances where the terms and conditions of the trading product doesn't clearly talk of attorney, but it's clear that any trade automatically happens on the follower's account, I think there's a problem from a discretionary perspective. Other things that are problematic is, of course, the fees that are payable to a master trader. Quite often, master traders are paid either based on the number of followers or potentially the results of those trades. And again, that aligns too closely to what is essentially seen as discretionary investment management. And let me talk for a second about what I think, well, before I get to that, the one other important thing to remember is in many cases, these master traders are not based in South Africa. Now, a Category 2 license can only apply to what you do in South Africa. The FACE Act doesn't have extraterritorial application. So if the master trader is in South Africa, this Cat 2 issues become relevant. If the master trader is not in South Africa, the Section 2 of the General Code of Conduct again becomes relevant. because the argument is then you are referring clients to offshore financial services providers, and you should, as an FSP, ensure that those people are appropriately regulated and have appropriate risk management, etc., in place. So both local master traders and foreign master traders are potentially subject to scrutiny. Let me then talk about what is potentially possible. So signal provision. Now, as a default, Gerard tends to say at the moment that if they're signal providers, then they are providing advice, and you need a Category 1 license. Now, I think as Lenny mentioned, there are shades of grey here. Clearly, if the context of what you're doing is there are WhatsApp groups, for example, or other forms of communications that come with these signals that state, I recommend that you do this trade, or I advise that you do this trade. That's clearly financial advice. That should be distinguished, though, from me providing you with a subscription to information. I mean, it's no different to me having a Bloomberg, account where I get a lot of information on financial instruments and potentially, information on what directors have done, if they've bought or sold. All of that type of information is objective information, which a client can then take into account or not take into account as part of his trading strategy. Now, I can't see any basis on which that can be advice, because there's no recommendation, guidance, or proposal. We would, of course, make it very clear in the terms and conditions that there is no such things. We are giving you access to objective information that you can decide to take into account when you make a decision as to how you want to trade. But again, whether that gets to that side of the equation is very much dependent on the nature of your terms and conditions, which one will definitely have to look at. Woodcraft matter, again, Gerard is very delighted with that, of course, because he, on reconsideration, got proven correct, insofar as copy trading is concerned. I think the Woodcraft matter was an easy matter to take, to reconsideration for the FSCA, because, as I've mentioned, they almost conceded that they were giving advice, and they almost conceded that there was discretionary investment management. Now, I think you can certainly structure your affairs in such a manner that makes that a lot less clear. However, the important thing that the Woodcraft matter has sort of established is the traditional copy trading product just simply does not work, and I think you will run into trouble with that. Let me pause there. I'm sure there'll be many questions after this, but like I said, I'm happy to stay online as long as it takes to answer them. I just want to give Des a couple of minutes to do her bit before the time runs out.
Thanks, Sean. Good morning, everyone. So I am, Rudin, do you want to maybe just move to the next slide? Thank you. So these were the 4 categories of complaints that I wanted to touch on today, just so you have some context. We had a look at the various categories of complaints that were submitted to the FAIR's Ombud in the last year. We pulled out a few of those that we think are topical for this audience. And the 4 that we wanted to talk about is what you see on screen at the moment. By way of background, the Ombud receives a substantial number of complaints every year. During the 2022-2023 year, they received something like 10,970 complaints, which, although it is a substantial number, was a reduction from previous years. But of this very big number, the majority of those complaints fell within the ambit of the Ombud and accordingly needed to be investigated by the Ombud. So just in keeping with the theme of this morning's discussion, and having regard to time, I think what we'll do is we'll focus on complaints that have come through from a crypto asset perspective, and then complaints that have come through from a Forex perspective. I think you can move on, Rudin. Thank you. So crypto assets, Lenny touched on briefly. What I'm sure everyone will agree to is that The success of cryptocurrencies like Bitcoin and Ethereum have effectively given rise to an entirely new investment industry in a very short period of time. And as a result, what we've seen is inexperienced investors that are being lured in by the opportunity to invest in crypto, whether that comes via local exchanges or foreign exchanges, but without necessarily appreciating the volatility of the asset class. In South Africa specifically, we've learned some hard lessons. You'll remember Mirror Trading International, AfriCrypt, lots of South Africans, billions of rands in investments, much of which was unfortunately lost. And from a complaints perspective, this trend is very evident. And we can almost break it down between complaints in respect of crypto that came before the crypto asset declaration, and then complaints that came after the crypto asset declaration. So without going into too much detail on the manner in which the regulation of crypto assets came about, where we are now is that crypto assets are a financial product under the FSCA Act. Previously, they weren't. From a complaints perspective, what that means is that up until fairly recently, large numbers of complaints that were submitted to the Ombud could not be entertained by the Ombud just because they didn't have the jurisdiction to do so. Since the declaration, however, there has been a substantial increase in the number of complaints that have gone to the FSCA Ombud because they now have jurisdiction to look at those and to consider them. So in a recent media statement, what came out of the FSCA Ombud office was that cryptocurrency, or crypto assets rather, are emerging as an entirely new asset class. Their appeal being that they offer an alternative to your traditional financial products. So instead of your run-of-the-mill equities and bonds and property, here is crypto now, which promises in many instances exceptional returns. While that is good news to an investor here, the general sentiment amongst our regulators, and we've seen this come out of the FSCA, the Prudential Authority, even the Financial Surveillance Department, is that these types of investments come with significant volatility, and consumers need to exercise caution if they are considering investing. So what does that mean for providers? I think in the first instance is, and the obvious step in light of the declaration is to check whether you need to be licensed as a provider of services in respect of crypto assets. If it is the case, consider your license, decide whether you need to add crypto as an additional product category. And if you haven't already done that, now is the time to do so. And then just from a recommendation perspective, following the complaints and the details of those, what I think is important for providers to remember is that if you're considering making a recommendation in respect of crypto assets, ideally you want this to come as part of a diversified investment portfolio. So, we're moving away from the days where grannies were told to invest their entire life savings into Bitcoin. Your consumers, or your clients rather, should have a high risk tolerance, a solid financial position, and perhaps the biggest caveat is that they must appreciate the risk that comes with crypto investments, and the unfortunately very real potential that they may lose a lot of money. We can move on, Rudine. So Forex investment complaints, and these tie in a little bit to the CFD world and online trading. Again, the realization that Forex investments are high risk, and can lead to substantial investment loss. And what we're seeing from the complaints that the Ombud is dealing with is that a lot of the pure Forex complaints stem from online trading and online trading platforms, and the manner in which these types of investments, so the platform route, highlighted one of the limitations that the FSCA that the regulator is being faced with, and that the Ombud is being faced with when it comes to protecting these consumers and addressing these complaints. And without going into too much detail, the crux of it is that often complaints arise where you have an investor and a client that has subscribed to a platform, accepted the terms and conditions, trades as per usual while having read through the risk disclaimers, and then loses money. When the losses start piling up, that is when the complaint is lodged. And from an Ombud perspective, what recent cases have shown is that when the Ombud then investigates these complaints, looks through the underlying documentation, what becomes increasingly clear is, one, that risk was accepted. Two, that in many of these instances, the provider was not giving financial advice in relation to these products. So where trades were entered into and where money was lost, a lot of those was at the instance of the client, of the individual themselves, without any recommendation or proposal by the provider. And what the Ombud has said, look, is that in these instances, they are bound by their rules and cannot intervene because the only time the Ombud has jurisdiction to entertain a complaint like this is where the provider has given an express or an implied guarantee on investment, which in most instances doesn't happen with online tradings. So what is the takeaway? I think from a consumer perspective, the obvious takeaway is if it sounds too good to be true, it probably is. And the FSCA has said as much in a press release that they issued toward the end of last year. From a provider perspective, what will become important is, one, assess your business against your regulatory framework. Take into account, the differences between the FASE Act and the ODP Act, all of the learnings that Sean, Kristen, and Leseko have imparted earlier, and understand where your obligation lies. And then, from a compliance perspective, then is to just put in place appropriate measures to make sure that you don't run the risk of contravention. And risk disclaimers, always important, often overlooked, but particularly relevant in the event that you need to justify your actions against an Ombud complaint. Rudin, we can move on. So I think just from a timing perspective, I'll leave retirement annuities. Just on property syndication, nutshell summary. It used to be that the Ombud received lots of complaints. They have recently decided to dismiss these complaints as being more appropriate on the rationale that they are more appropriately dealt with by court, given the complexity of the complaint and very often the factual detail that is required to appropriately consider these complaints. So we have just over 1,000 complaints that have been dismissed by the FASE Ombud. Letters were sent out, and the recommendation was that complainants approach the courts. From a provider perspective, look, if you were a party to one of these complaints, you would have probably by now received notice of the dismissal. If you haven't, and it is still to come, things to keep in mind, two things really. One is prescription. So under the Ombud rules, once a complaint is lodged, prescription stops running, and it starts running again when a determination has been made. If the determination in this instance is dismissal, presumably it means prescription is running again. So if you are defending a complaint, it will be to assess how that operates in relation to your matter. And second is liability. So some of the earlier decisions that came out of these property syndication complaints were that the advisors, the providers then, were in some instances required to make good on investment loss. And there's much debate about whether that level of legal liability is correct in these instances, given what your obligations are under the General Code of Conduct. So just two things to keep in mind if this is a scenario you're facing. I am going to stop there. Thanks, Rudy.
Thank you very much, Des. Insightful. Then, yes, are we available for questions? I know it's over the time, but we're happy to stick around for a while if there are any questions. Must be some. Make a point of making our presentation less clear next time.
Sean, I think there's some in the chat.
Yeah.
Oh yes. Are we? Sorry. Okay.
Yeah.
Sorry, Rudine. Were there any that we missed as we went along? I see there's here one from Kay.
Yes.
Can we use a wallet company's technology and licensing to offer to our clients without getting a crypto asset service provider license ourselves? It sounds like yours, Des.
So look, I think it will depend on what are you saying to clients in relation to that wallets company. So you just a little bit of color around what your offering would be in the first instance and how the wallet company would fit into that, I think would be useful so that we can give you an answer on this one. I'm not sure where the K is still online. There we go.
Yeah. So I mean, I don't know the intricacies of it. I'm just thinking about it sort of out loud. But if you had something like Luno has a service and a technology, you essentially want to offer that service and technology maybe on our own app. Make it look like ours. I mean, obviously be very clear about the agreements in the terms and conditions. But it's, could we then rely on their CASP license and things like that to offer it then on our app or platform for our own clients to invest in? Again, terms and conditions are stated clearly.
So look, I think it's probably okay now, particularly in light of the CASP licensing. So I'm not sure whether Luno was on the list of the providers that recently got their FSP license, but assuming that they are, and going back to what Sean said about Section 2, you would in fact be, let's not call it referring, but encouraging or making available the services of another licensed entity, which should be fine. Obviously, though, like you said, how you explain that in your documentation will be very important, particularly from the perspective of, from a client perspective of seeing where accountability starts and ends, both with you and then with Luno in your example.
Thanks very much.
I see we've got
maybe I can add
comments.
to that.
Oh, sorry, Lenny.
Just to add to Kay's, so Luno may be deemed to be a product provider. So it very much depends on the service, Kay, that you render to the client vis-a-vis Luno's offering. So I think you need to look at that business model carefully, because you could be seen to be referring a client or recommending an offering that they have in terms of that wallet. So I don't think it's as simple as maybe as that. It's simple. It's just a wallet, but I do think that each case needs to be assessed, and that business model that you have. What is it that are you making a recommendation to use Luno? You could be touching on the requirements of the General Code Section 8 in terms of advice or recommendation. So you need to look at it quite carefully and see whether you may be rendering a service, just purely through referral. Yeah.
Thanks, Denny.
Yeah, look at the model and wording
a...
carefully.
Sorry, I think
Go,
I
it's
might
fine.
I see there's two other questions around the COFI bill and the removal of the juristic rep structure, and then also on the trade repositories, I think. So the second one is there a regulated process for trade history reports repository? Let me maybe answer that one first. So there is, of course, in the regulations, the requirement once a trade repository exists to report trades above a certain level and certain types to this trade repository. I think there's a lot of work still to be done. We were involved originally in trying to set up with a particular client a trade repository who then sort of pulled out of the process sort of midway through, on the basis that I think the regulated fees that they were considering at that point just didn't make it worthwhile. At the moment, I don't believe there's a trade repository in place, Des, I've got it wrong, for ODP transactions. The type of information that will have to be reported, I think, will probably also come through in more detail once that. I mean, there are some general, indications at the moment, but I think there'll be some conduct standards around that once the process actually starts. But it seems to me we're probably another couple of years away from actually having to report. The COFI bill, just my 5 cents worth. I'm sure Lenny and Des would have some insights here as well. But the juristic rep issue has always been an issue for FSCA. The white labeling of licenses has been problematic for them. I've seen it quite often in practice around private equity investments, for example, as well. And there are some problems with it. People tend to think that you get a juristic rep appointment and that's sort of where it ends for you. And often the relevant Cat 2 also thinks that. And they've very often opened themselves up for quite substantial liability related issues, especially for the KIs of the Cat 2, where the juristic rep has gone off on frolics of their own and they weren't properly supervised by the relevant KI. So I'm pretty sure it's around those abuses is the underlying reason. But Lenny and Des, do you have any comments on that?
I think you're right, Sean, on the juristic rep point. We see that more and more. And I think the FSCA's concern is to move away from the fact that you can almost rent a license, because for obvious reasons it doesn't make sense from a regulator perspective. Just on the COFI bill, quickly, that seems to be never ending. It reminds me of Poppy in some instances, because it was around in some form for many years before we saw any sort of realization. As it stands at the moment, comments were put in on the second draft. We haven't heard anything from National Treasury since then. If you follow the media, it pops up every now and then that it's close to completion and it will be passed into law. The FSCA has given us moving targets as to when that will be. But the short answer is we don't know when it's likely to come into effect. But my suspicion, at least, that it is not going to be anytime soon.
Yeah, I think the COFI bill will change the whole nature of the industry. I doubt that there will be a juristic rep structure under that. I think the COFI bill has various tracks based on the nature of activity. For instance, they will incorporate things like corporate finance that has always stood on the sidelines of the FASE Act. The purchase and acquisitions of companies, do they fall within FASE or not? In the strict reading, I would say yes. However, juristic reps for the FSCA and for us as compliance officers do create problems. An FSP with a juristic rep is more highly scrutinized by the FSCA. It was an area of scrutiny a few years ago, and they did site visits typically on FSPs that had juristic reps. Being a juristic rep does bring risk to an FSP. The FSP is responsible for that juristic rep, and that juristic rep will have to operate to the same standard that an FSP does. It has to submit financial statements. Its financial soundness needs to be at the same level as that of the category of license that it sits on. So it's not just simply, in a sense, there is a bypassing of the due diligence that happens during registration at the FSCA. So it's not an ideal model. It does bring risk. I can see instances where it works in private equity, for instance, where you have a fund manager that then advises, the general partner of a non-commandite partnership. They really do operate together. It's part of a bigger structure, and in that instance, it makes sense. It works as one unit, but it has been abused. There was an FSP that was in the motor vehicle dealership sort of space. They placed 200 to 300 to 400 juristic reps on the license, and there's just no way that FSP could have oversight over that. So there were abuses. I think that we will see an end to that. I don't see how that, it's a little lacuna, to use a word that Sean, it's a little loophole that I think is not ideal for the industry or for the regulator. And I think COFI will deal with that. And I don't think, my view is, I don't think we'll see that type of structure allowed under COFI.
Thanks, Lenny. Just one final point on COFI. So again, I don't want to get into it too deeply because there's so much that could potentially still change there, as Des has mentioned. But there's going to be pretty much a wholesale reconsideration of your business that's going to have to happen once that act becomes an act. There are, as Lenny mentioned, merchant banking type activities, which wasn't regulated in the past, now clearly falls within the ambit. You have a variety of other things, like administrative services are now potentially a type of conduct that you will need a license for. A variety of other things which we currently don't even think about. So again, once that gets close to fruition, I think the only people that will be particularly happy about it are lawyers, because it's going to require a lot of work. But it's so uncertain at the moment that I wouldn't worry too much about it. We have done some training sessions on what it currently says, but I think it'd probably be more useful, those sessions, once we have a closer to final version. Other comments or questions?
Sean, I've got one quick one, sorry.
Sure, no
if
problem.
a signal provider is regulated under the FSCA in the UK, would they be considered able to provide a signal to, a South African client?
So you're saying that the party providing the signals is based in the UK? That
Yes.
actual action of providing the signal is regulated in the UK jurisdiction. Now, again, because the signal provision is not happening in South Africa, again, and that's something one will have to assess. But if it's not happening in South Africa, then of course there can't be advice in South Africa. Referring your clients locally, if a local FSP refers clients to that offshore signal provider, then I think you need to ensure, as we've mentioned, that you comply with Section 2 of the General Code of Conduct. And if that signal provider is regulated in respect of that type of service in the UK, I think you have a pretty good argument that you have not breached Section 2.
Yeah, because I completely understand we shouldn't have any signal providers based in South Africa unless they regulate
yes,
to
but
provide
again,
that advice.
Sure.
Yeah, sorry.
But as I've mentioned, it's important to distinguish which are the problematic signal provider, the problematic signal provision business, and which is not. I think, Gerard, by his own admission, says that there are certain types potentially that would not constitute advice. And in my view, those are the instances where you essentially give people access to information without any guidance or recommendation that comes with that. In other words, it's a bit like saying, I give you access to what the directors of all the listed companies have traded in the last 6 months. Nobody's going to argue that the directors are giving me financial advice. It's simply information that I take into account in making my own investment decisions. So if it's structured in that way, I think it is possible to avoid giving advice. But again, very subject to what you do in each case, and subject to your terms and conditions that come with that. But also subject to, because I've had clients who told me, No. We're just giving very objective information. And then they send me a screenshot of a WhatsApp group where the signal provider tells people 2 or 3 times, I think you should buy this. I mean, that's clearly advice. So just be careful what actually happens in practice. I mean, you can have all the disclaimers in the world. If what you do practically differs, then the disclaimers are not won't help you. So just keep that in mind.
One last one. Obviously, Gerard focused on education. There are a lot of educators out here that would have a group, for example. It might be a Teams group or a video group where they would trade live in front of an audience, or they would do something. Is that considered advice? I mean, it's part of an education and a learning process, but somebody that, I might have my MT4 screen up or my trading screen up, and I'm talking about levels and I'm talking about things that are happening in the market at the time, and I place a trade. Would that be considered advice?
Well, again, I think it's subject to the facts of that particular matter. I mean, if you are teaching somebody how to trade and it's a generic course around how, certain trading, strategies and how you would affect them, but they don't relate to a specific. I mean, it is just an education as to how a certain type of activity works. Then I think you can argue you're not giving an educational program. But again, these things quickly merge into more than that. So as soon as those people start suggesting to clients that they should, for example, buy a particular type of derivative if they have a particular, outcome that they desire, of course, that's going to, again, be advice. So it depends how far you go. Sorry, Lenny, I know that you've had more practical experience on the enforcement issues around this.
No, I just wanted to raise something, and that is that the FSCA has already put out a draft conduct standard on financial education. And I see that Jimmy is on the call here, and in the interview with Gerard at the conference, there was quite a lot of discussion around financial education. In the conduct standard, the draft conduct standard, there will be regulation that is coming on financial education. The principle that Jimmy and Gerard spoke about is very valid, and that is it has to be education on how to trade, what are products, what is this instrument. It's academic type information. Typically what happens at these education courses is that at the end there is some form of recommendation of recommendation of various brokerages, and that's where the conflict of interest lies, and that's where you could be caught into an advisory situation where you are recommending the services of a particular product provider. And the conduct standard does go into that, and it prohibits that kind of recommendation after a 2-hour course on trading. So I think the regulation is coming. There is a draft already. I'm not too close to it, but I have read it. So it is an area of concern, without a doubt. And if you do provide courses, it's best to provide it on an academic basis. And I think Jimmy spoke about having his course NQF regulated, and the story stops there. You are educated, but there's no recommendation of a broker, and that's where I think that sometimes the distribution model used by the CFD brokers needs to be relooked at, and there is an obligation on them, in terms of ensuring that whoever they contract, currently leads generation is unregulated under the FASE Act, but that is a pure name provision, the provision of a name. But when you go further and you educate, but then with an end goal of perhaps introducing a client to a particular broker, and then through that introduction you are remunerated, it does sort of lead towards some kind of financial service. So it's a tricky path, and there is a conduct standard coming. So be on the lookout for that.
Then I just want to quickly talk to Quibus's question. Quibus, it's a tricky one. So as a starting point, any South African resident, exchange control resident that wants to open a foreign bank account has to obtain exchange control approval for that. And this is also something which people don't, often realize is, no South African exchange control resident, so that will include any South African incorporated company, can open a bank account in a foreign jurisdiction without that account being approved by the Reserve Bank. And there are specific requirements for that, those accounts to be approved. Now, in the context of EMIs or electronic money institutions, I understand, having looked at this in the past, and again, there's no clear answer because I don't think it's been considered too often, but some of these EMIs don't involve the client having its own bank account, and client funds are sort of pooled in sort of custody accounts, but you don't have your own specific bank account number. That it's arguable in those instances that the client itself did not open a foreign bank account. Of course, how the money goes offshore from the underlying clients must still be subject to the applicable exchange controls. But you could argue in those instances where funds go into a globular sort of client account and is not a specific bank account that attaches to a specific client, that there's no foreign bank account for these purposes. But again, I must say that is not being tested. Exchange controls are not, unfortunately, like other laws where you simply interpret them and come to an answer. They are a bunch of policy considerations which the Reserve Bank can frankly change without notifying us. I mean, they'll notify the authorized dealers, but one will have to probably speak to authorized dealer banks about that to get a slightly better idea. But I think it's arguable for certain types of EMIs that you're not opening a foreign bank account. Any other questions? Well, maybe then, all that's left is me to thank everybody that's joined. As we've mentioned, we will make the slides available and we'll also make things available. So I think just please let us know if you would like that and we can send that to you. Let's make sure there's nothing else. No, I think so. I think not. But thank you, everybody, for joining. And we'll certainly let you know once we get more information on some of these things, and we might arrange another session at some point.
Thanks, everybody, for your time.
Thank you.
All right. Well, goodbye, everybody. Have a good day.
Bye-bye.